Hello and welcome to Defense Diaries. I'm your host, Bob Mata, and this is our continuing coverage of the people of the state of Indiana versus Richard M. Allen. So back home is where the heart is. It's been a long month, and it wasn't nearly as long as it could have been for all my line sitting friends. They went through a whole different ordeal. It was still grueling, incredibly grueling. It was all consuming for about 30 days. It was a lot. And we got our verdict a couple of days ago, and I wanted everybody to be able to kind of like digest it, try to take a breath, try to think about it, and including myself. And then I figured that now would be a good time to come on and discuss it a little bit. And more importantly, I wanted to give everybody out there an understanding of where this process goes from here, from one of the best in the business. And I'm excited that Cara Wieneke is going to be joining me probably at about 3:40. So I'll have a fair amount, like 8 minutes to rant before she comes on. But Cara's going to walk us through the appellate process. I think it will be very informative for everybody out there so that we have a better understanding of exactly how this process is going to work, what it's going to entail, get a pretty decent idea of timing. And it's, if you've been following my content from the beginning, and if you're not, if you're new from the lawyer, I had a great conversation with Peter over on his channel a couple days ago. So I might have some new viewers over there. I really enjoyed that, and I thought that it was enlightening in a lot of different ways. And this is my feeling, because the night of, when you're kind of sitting there and you go live a couple hours after the verdict came in, you're still kind of in that fugue state. You got a lot of stuff running through your mind. And as a lawyer, I probably had very different things. Or Andrea, welcome, Cammie. I probably have different things running through my mind as opposed to a lay person. Like, my mind probably immediately went to like what could have come out that would have changed this verdict in terms of that jury. And, as opposed to being shocked or things like that. And I just want to be clear what my position is with respect to this jury, and their decision. And kind of the best way to describe it is that, as a lawyer, whenever I tried cases and we were awaiting a jury, we talked about it. I talked about it when I was on with Andrea and lawyer Lee. Just kind of that, I think Andrea called it I forget what she called it. There's like a period of time where limbo. She called it limbo, that limbo period where you're sitting there and all you feel is anxiety, and your stomach is in knots, and it gets progressively worse as you um if you get in there, uh and then when the judge comes out, and then the verdict is finally read, and at that point, as the defense attorney, then you deal with all the emotions that come flooding in that moment. And this was oddly very similar for me, even though I was not in any way involved with the defense in the case. I was obviously close to it, and I obviously had a friendship with Kathy Allen, and my role with her was to explain to her what was going on a daily basis in that court, good, bad, or indifferent. I mean, if there were days that I thought didn't go well for the defense, I was telling her that. If there were days that I thought went well for the defense, I was telling her that. And then trying to kind of remind her to breathe as we were waiting for this verdict, because it sounds like a funny thing to do. But a lot of us forget to breathe in stressful situations, and it can really help. It would really help be able to calm nerves a little bit. It certainly allows you to feel a little less anxious if you remember to breathe. So, and I just like sitting there when they read the verdict, like I didn't know how I would be feeling if they read a guilty verdict or if they came back with an acquittal until the moment it happened. And then I realized at that moment in time that as defense attorneys, we are accustomed to hearing guilty. We're unaccustomed to hearing not guilty. And when they read the verdict of guilty, I was not surprised. Like that was my initial instinct. It was not at all something that I was like, wow, I can't believe it. And I realized that it would have been, wow, I can't believe it if they had acquitted him. And it had nothing to do with the facts or the evidence that came in. It had nothing to do with that case, and it had everything to do with what I'm accustomed to as a defense attorney and what I know that the reality of our system is. It's shocking when a jury comes back with an acquittal. It just is. If you think back to every time that you've ever watched any trial that you've been following adamantly, and even no matter which way you're feeling, no matter which way you're feeling, if you're feeling like, oh my God, I feel like they should come back with a not guilty verdict. And then when they do it, you're still like, wow, that just happened. That tells you something. The conviction rates are anywhere from 95 to 97%, depending on whether you're talking about state cases or federal cases. You know, it's you get convictions in these cases. So in those times when you get a not guilty verdict, it's stunning. And it could be stunning in a way that Casey Anthony was stunning, where everyone was enraged, or with OJ, where you got a not guilty verdict and everybody was either elated or enraged. Like it went both ways with that thing, and OJ, while I think that he is the person who committed those crimes, I did not think that the state had met their burden. Those are two different things, which kind of leads me into what I'm about to say. And as I sit here today, and if you've listened to my content from the beginning on the Delphi case, I have told you unequivocally, I've never been shouting that Richard Allen's innocent. I don't know if Richard Allen's innocent or not. I wasn't there. Anybody that's so sure on one side or the other of innocence or guilt and who wasn't there is doing nothing other than guessing. Okay. So, what my position has always been on that case, on Rick's case, is that particular probable cause affidavit, which ended up being the sum total of their evidence, if you take away the confessions, which you can't, but the sum total of their evidence was exactly what they had in that probable cause affidavit. And I spent an awful lot of time arguing early on with people that had no business arguing with me about procedure in the law because they didn't do it for a living, that was it, that they might get some more stuff post arrest, because that's when they're going to have access to his devices. That's when they're going to have the most access to the defendant is post arrest. They're going to really be able to dig in on that particular person in a much more meaningful way than they can pre-arrest. So my position had always been, and it remains, that leaned innocent. And I maintain that leaned innocent. What that made me feel is like that they don't have the right guy, or that they don't have enough evidence at that point in time to prove beyond a reasonable doubt that he is the right guy. And as I sit here today, I accept the verdict. I don't like the verdict, but I accept it because that's what I'm trained to do. I know Michael Osbrook. I see you, Michael. I'll send you a link. I know Michael is talking about like, I don't have to respect verdicts. I've been doing. Yeah, you do. You do. It's our system. We don't have to like them, and we attack them after the fact, but we still have to respect the fact that the jury sat there. They heard the evidence that they were allowed to hear, and they made their decision based on that evidence they were allowed to hear. So it's a different thing. It's a different thing. So where I sit here today is that I wish that I could say, well, God, thank God they got the guy. I wish that I could feel confidence that the man who is now convicted of killing Libby and Abby is the guy who killed Libby and Abby. And based on what I just observed firsthand for the better part of 3 weeks, 3 weeks and change, is that I do not feel comfortable with the verdict. I feel terrified with that verdict, is where I'm at. And no one's going to change my mind about that. Everyone can have opinions on it. For those that feel secure in the verdict, that's that's your prerogative. You're allowed to feel that way. I feel very differently. I feel that in light of everything that came out at that trial, that we are sitting here with a guilty verdict of a person that I just don't know one way or another whether he did it. And we need to feel comfortable. We need to feel as comfortable as we can, and which is very difficult in a circumstantial case. It just is. It's hard to know. You can't really know, right? You can't know for certain. I mean, there's those cases where you can know because they have very powerful evidence. And if anybody out there is being intellectually honest, this was not that case. They did not have the type of evidence where you can sit there and say, "Oh, I know he did it." They proved it. They had all the evidence they needed, because they didn't. They didn't. And what they did is they extracted these confessions out of a man by torturing him in a country where we don't allow that to happen. And I hope to God that those videos, at the horror of Rick Allen, of those being put out to the public needs to see those. The public needs to see those videos. They need to see how an American citizen who's presumed innocent was treated in a prison for 13 months in order to truly understand whether or not we can give any weight to those confessions. Because I am confident, and I am giving I'm making an offer of, I would love to be able to speak to one of the jurors. I would love it. Because if only to ask one question: what decided it for you? What was the deciding factor? What pushed you over the edge to vote that Richard Allen was proven guilty by a reasonable doubt? And I will be stunned. I will be stunned if, in fact, it's anything other than those confessions. Stunned. And so that's where the battle in the appellate process is going to start and finish. And Michael, who I will bring on after I have Cara on, because I know that they're having a little bit of a dispute in terms of how that process should go. For the record, I'm going to say it right away. I'm on Cara's side in terms, because Michael, I know which way you want to go with it, and we'll talk it out when I have you on. But without further ado, I want to bring on my guest. I don't want to keep her sitting back there, so she can explain exactly what we can expect from this process moving forward. She's a brilliant attorney. She does appellate work in the great state of Indiana, and I respect the hell out of her. Cara Wieneke, how you doing? Thank you for
Good. Can you hear me?
I can hear you crystal clear.
Excellent.
Crystal clear. How you doing? How you doing?
I'm doing well. I did get to talk to Andy today to see how he's doing, and he's doing well. So, or as expected, I should say. He's going to take a few days to recuperate, and he's back in the game. So,
yeah, it is going through like a trial like this in terms of the amount of brain power that you're using, in terms of the amount of stress that you're under, in terms of the preparation that it took to get to that point. It is exceptionally exhausting. Like I can't put it, like, in every way. You feel physically drained, you feel mentally drained. They're going through obviously the feelings of, massive disappointment. They're going through the feelings of like, oh my God, an innocent, because every one of those attorneys, whether you ask Brad, whether you ask Andy or Jennifer, all believe that Richard Allen is innocent, factually innocent of this crime. So they're having to deal with another layer of just kind of a nightmare scenario for them. So yeah, it's understandable. I had told Brad, in a conversation that we had after the fact, I'm like, look, man, you gotta take 3 weeks off, a month, just to recoup. Like, I mean, you're no good to the rest of your clients if you're coming in just, a puddle, so, and you can't help but feel that way. Unless you're in a situation where, you're oblivious to what's going on around you. So, all right. So here's what we need from you, Cara. So we need to pick your brain, and we need you to walk us through this step by step. We have a conviction. Tell us, what is the next thing that's going to happen after sentencing?
All right. So sentencing, December 20th. I expect that the victims' families will have probably most of the day. I think she set it for a day to be able to really express, that's a tough time, because, you really feel for them for that. I don't expect there will be much from Rick's side. He may have people speak out on his behalf too, but really, I can't remember how old he is, but in the grand scheme of things, whether he gets the minimum or the maximum, it's a life sentence. It's de facto life for him. So, that's, I mean, we go in knowing that. So at the end of sentencing, she'll announce the sentence right there. And she may take a few minutes to think, but my guess is she's probably thinking about it now. And then she will ask what he wants to do about the appeal. Is he going to appeal? Yes. Does he want counsel appointed? Yes. He's been found indigent, so he'll want counsel appointed. And then she'll appoint counsel. I don't know if she's having discussions about who she might appoint, or if she'll just figure that out later, but that's when she'll say, okay, we'll refer the case to whomever. After that, he's got a couple of options. You have 30 days to decide what you're going to do. So he can either file a notice of appeal, which goes to the Court of Appeals. We have an intermediate court, goes to the Court of Appeals. They can decide, he can decide to go that route. Everything's filed in the Court of Appeals. Or he can file a motion to correct error. In most cases, motions to correct error aren't filed. Here, though, this is where you can raise issues of juror misconduct or something else jury related. That's the most common. If there's newly discovered evidence between now and then, and it couldn't have been discovered for trial, or dealt with at trial, you must raise that actually in a motion to correct error. Or if there's any, you don't have to file a motion to correct error, but you can if you want to, and raise other issues, other claims. So he's got those two avenues he can go. And so what he'll do, usually the appellate avenue is what the appellate attorney will focus on. If there's a motion to correct error filed, that would be by the trial counsel, because they're the ones with the appearance in the trial court. But
let me ask you a question. So what is a motion to correct errors? Like, break it down so that the people that don't practice appellate law, so that they can understand it.
Some people call it like a motion for a new trial, but it's a little bit even more than that. If you think the court has made an error that would entitle you to a new trial, or you've learned something since the trial, or you think she's made an error about a sentence or anything, you can raise it. There's only certain claims you have to raise it before appeal, and that's newly discovered evidence, or that's probably the only one that I think is covered as mandatory in a criminal case. Because the other ones, jury verdicts is excessive or inadequate. That's going to be civil. But that's whenever you have to file it. Otherwise, you can file it if you want, but you don't have to. But the most common time is if a juror comes forward and says, I don't know, I knew somebody and didn't tell you, or something happened, some sort of juror misconduct. That's where I see it filed most often.
Okay. All right. So, and again, like, just to understand that will be denied.
Yeah, probably without a hearing.
Right.
You don't have to hold a hearing on one. Yeah.
Right. So that, and here we call it a motion for a new trial. We've never won one ever. So I just like to try to prepare people so that they're not enraged at the time that's filed, if it is filed, and Gull denies it. I mean, that's pro forma. It's just kind of par for the course. Here, we have to file our motion for a new trial before we file our notice of appeal. So that's why I wanted you on, who's an appellate attorney in Indiana, who can explain us exactly how the process. All right, so keep going. After that's filed, then explain the process of getting that record put together for the appellate court.
That's going to be a lot, because we put together a mini record for the two original actions, and that took a lot. Basically, what has to happen, I don't have support staff. Other appellate attorneys often don't, so we put them together ourselves. But essentially, you have to, in a criminal case in Indiana, everything that's on that docket has to be in your appendix. You can ask for permission to take things out, but you have to ask for permission. So you might as well just put it in there, right? Takes you about the same amount of time. So that's going to be and everything's electronic. So you have to put it all together, bait stamp it, create your own table of contents, and file it. And so that's going to be a lot, because we had not only things that were confidential. Well, the appellate attorney will have access to those. But I think there were things that maybe didn't make it on the docket, or if they made it on the docket, I just remember even after the first original action, there were some hiccups along the way. And so what's going to happen. So for example, the Franks memo, I think the first one, there were a ton of exhibits that were attached to that memo, but those were not on the docket. Might have said there were exhibits, but they weren't actually anywhere. I can't click on them, right?
Right.
Those are going to have to be obtained, because every single thing that the judge saw, the Court of Appeals needs to be able to see. Yes. And the same thing with hearings. We have to figure out all the different hearings in our appeals that we want, and then we have to make sure that all of those hearings are given to the Court of Appeals, because they won't go looking for it. They're going to want it all given to them. And so you have to make sure you've given them everything.
Yeah. And that goes to the point where for the first 18 months of me covering this, from the minute that the probable cause affidavit was sealed all the way through, and through all of the motions that were filed by the defense that weren't scheduled for hearings, that ultimately would be scheduled for hearings and that she'd rule on. And all of them didn't require hearings, but some of them did. But the way that the record was being kept in terms of the docket was a shambles. And, so when I was complaining about that all the time, this is the part of the process where I was talking about where it's going to matter. all of those things, because the appellate court wasn't sitting at trial. They weren't paying attention to what was going on at this case, at least theoretically, pre-trial. So they don't have any idea. Their record is what it is. And that's why it's so important for judges to keep a clear record of the procedural posture of these cases as they move forward. And it just didn't happen here. And, we're going to finally get some input, hopefully, from the appellate court about this thing that she would do, where she would, just rule on hearings or motions without hearings, not supply any kind of basis in the law as to why she made those decisions. It was like trying to pull teeth to get her to give her rationale as to why she made certain decisions. I mean, the only thing that I've really seen her latch onto was she loves to say that you didn't prove that there was a nexus. She loves to say that. That's her favorite thing. That's her favorite thing to say out of all the procedural motions that were filed pre-trial, was that you didn't show me a nexus. You did not demonstrate a nexus that would, require the use of admissible evidence at trial. I'm sorry. You can do whatever you want to do, but I'm not seeing that nexus. So as far as any of her rulings, that's the only one where I'm very clear on what her position is as to why she denied it. So
some of that may be too, because she knows the case law, that a lot of times on appeal, if she's made a ruling on one ground, but the state comes up with a different ground on appeal for why something should not have been admitted or should, the appellate court will generally, if the ruling is it comes in or it doesn't, the appellate court will generally uphold that if they can find any other ground. It makes it a little bit harder for the party who's appealing to be able to win on that. Now, her saying, I don't think there's a nexus, well, that helps a little bit in that, we have a specific ground that she decided that on. But some of the objections and things, those that followed the Karen Reed case, that drove me nuts. It was like, objection, you weren't allowed to state your ground. I thought, wow, that would be crazy as an appellate attorney. But, that kind of happens. And we get that on occasion in trials too, because especially with learned judges, they don't need to hear, they know why you're objecting, right? So that they're ready for it. But.
Right. And so, I reached out to you yesterday, and I think my question to you is what do I need to do to get you on board to file, to be his appellate lawyer? And you said it was a 2-word answer. You said, call me. We had a very long, productive conversation. In terms of the timing of just potentially worst case, give us a timing of best case scenario, worst case scenario,
all right.
Understanding that it's an estimate.
So here's our appellate courts are some of the most efficient in the country, and they will tell you that they are very proud of that. And that's sometimes good for our clients, but sometimes for attorneys, it can be tough. When we file that notice of appeal, that triggers everything. And so the appellant will have, the trial court clerk will have 30 days to file this notice that really, it doesn't mean anything. It just means, all the paperwork's together, meaning the court file. They file that, and then also the court reporter from the filing of the notice of appeal has 45 days to prepare the transcript. I would be shocked if she did not ask for more time in this case, because this is going to be a big transcript. She's either going to have to, farm it out to somebody, or she's going to be working nights and weekends for a while. So they'll give her some extra time, but they're not going to give her 6-8 months necessarily. So, they're pretty good about giving you maybe 1 or 2, and then they're going to start, talking to you about it. After the transcript is done, theoretically, we have 30 days to review everything, write up the initial brief. It's sort of an unspoken rule. You can ask for a first 30-day extension of time. They'll almost always grant it. And then if you need 15 days more, they'll almost always grant it. But they're going to tell you this is it in the order. And barring really unforeseen circumstances, they're not going to want to give you any more. So it's a pretty tight deadline. So I think anybody that takes this appeal, they're going to have a team of people, because I don't see a lot of appellate attorneys in Indiana that are going to be able to drop everything for 3 months and just do this case the whole time. We have a shortage in Indiana. We have a shortage of appellate attorneys in Indiana. People are going to be stretched pretty thin already. So it's really going to take a group of people.
For sure.
Yeah.
And, and kind of the other part of this is that there's cost, obviously the cost of, so if Rick Allen, who is currently deemed indigent, meaning he doesn't have money, if he's appointed appellate counsel, in theory, what can happen is that in that scenario, they don't have to pay to have the transcript and the record prepared, which, as you told me yesterday, can be astronomical.
Right.
We're talking $40,000, $50,000. And then, so maybe the approach is to have him appointed counsel, have that done, because say, for instance, he's able to get you and a couple other great appellate attorneys in Indiana to say, yeah, we're all about this. But you guys have to come up with the money to, try to get that record prepared. Like, is there an option that you have that might work in terms of, because if he's able to raise capital to get an appellate attorney or a team of appellate attorneys, but it's not enough to cover the cost of getting the record prepared and to pay the appellate attorneys for their time and their hard work, what is the option that he has?
There is a process. You can ask the Court of Appeals to waive or treat him as indigent for purposes of fees and costs, but allow him to have his own attorneys. We've done that in cases where counsel's pro bono, for example, or where counsel's low bono, where you're charging well under the market rate because he can afford that, but he can't necessarily afford the transcript. A lot of times in a case like this size, there's a good chance the transcript might be as much or more than the attorneys would charge, because it's just that big of a transcript. So that's going to be the hard part. I think he's going to, really, he's indigent. He doesn't have money for the transcript. So he's really has no choice in that respect.
Right.
Yeah.
Exactly. So, all right. So let's kind of get back to the time. All right. So say you get the direct appeal done, and when we get Michael on, he's got a different concept that
Right.
I'm going to let you guys battle through it a little bit. I think it'll be a really interesting conversation with the potential pratfalls of that approach as opposed to the direct appeal. But so let's say the direct appeal is denied. Okay. And where do we go from there?
So Court of Appeals denies the appeal or grants it, whichever. The losing party is almost certainly going to ask the Indiana Supreme Court to review it. Indiana Supreme Court is a shortened, they give you 45 days to file a petition, fairly short petition, and then it's 20 days to respond, 10 days to reply. So it's a much shorter time frame, and then they take maybe 4 to 6 weeks to make a decision. If they decide to take your case, they'll set it for an oral argument. If they set it for an oral argument, now we can't estimate. They'll give you the date, but then they could take the case and work on it for a year. They could take the case and release a quick decision. So you're really at their mercy. But we're looking at I usually tell clients, expect 9 months to a year if you go all the way through the process. That's in a normal case. This one might take a little bit longer. And then, of course, you always have the option of trying to go up to the U.S. Supreme Court and filing a cert petition. Some of us know how to do that, but it's a lot of work. And so usually the only time I'll suggest that is if I can find a law school clinic who might be interested and take the case up on your behalf. But you have to have federal constitutional claims to do that. Rick Allen has some, but the chances are so small that usually it's not an option in most appeals. So, and it delays the time depending on if you won or lost. So
as an appellate lawyer, how do you identify issues that are viable for the appellate court to review?
You know, a lot of people do, they call it the kitchen sink approach. You grab every single error and you throw it in there. And there's going to be, whoever takes this case, that's going to be a temptation, because there's going to be a lot of things they think would have been done differently or should have been done differently. But you have to be careful, because if you throw the kitchen sink at the court, a lot of times they look at it and say, you don't have anything. So you're trying to find something that will stick.
Right.
So in my opinion, there are going to be some errors that may need to be let go, smaller errors. You're not entitled to a perfect trial, just a fair one. So you've got to pick and choose. Plus, you have a page deadline or a page limit. You've got to stay within that. You can ask for more pages, but they're not going to give you a lot more. So you have to really be very careful. That's part of the art, right, of writing appellate. You've got to figure out which issues resonate. You have to look for themes, and you have to create your own theme of what went wrong on appeal, and then try to, you know, project that to the Court of Appeals.
Yeah, and like in my estimation, and we talked about it yesterday, and I'll preface this by saying I am not an appellate lawyer. I'm a trial lawyer. They are very different things. We do very, very different things within the same system. But to me, the primary attack has to be on the confessions. And so kind of like walk us through that. Is it an issue of whether or not they were voluntary? And is it an issue of whether or not they should have been admissible? And like, what does that argument look like from like a global perspective, like without having to get too much into the nitty gritty of it?
Well, usually what I try to do is I try to just look at everything in the order that the jury did. So I will read the transcript from beginning to end, and then I try to figure out, if I'm the juror, what bothered me, why would I convict, right? And I try to pick out those key pieces of evidence. Well, we all know what the key pieces of evidence are, because we sat and watched your lives and everybody else's to see, you know, what the evidence was. So it's obvious what's coming forward. You have to deal with the confessions. Now, on what grounds we'll deal with them, that's a good question. Or I shouldn't say we, but whoever, what grounds they're dealt with, good question. That'll have to be something that the appellate attorney looks at. But you have to, because even if you've got other really good issues, if you're not attacking those, the Court of Appeals could come back and say, hey, but these confessions, because of these confessions, your error you think should get you a new trial isn't actually that big of an error. So you have to really, and you have to find a way to do it where there's a theme, where you have your own theory as to what went wrong, and try to make it all make sense and tell a story. You know, that's going to be a hard part because of the size of the case. But, you know, I think trial counsel really, they had a theme, a theory that they were putting through in their motions. And so a lot of times you just can carry that on through.
Yeah.
But, you know, the confessions I don't know what they look like, because I only heard descriptions, right?
Right.
I have no idea what actually came out. I have no idea what arguments were made, because the sidebars weren't
Right.
broadcast.
Right.
Yeah.
So, and that's absolutely true, because in terms of, I was going to ask you, like, we know that the camcorder, what they call the transport videos, which is when they were moving Rick from place to place within the facility, that everything was recorded. He was never not being recorded, but that had sound. Now, initially, I think that was entered into evidence, because I don't think that Gull had heard that had sound, which, when you are going back through, if you do indeed end up handling this appeal, I want you to note that during the safekeeping hearing, I think the first one in June, it might have been the second one, that the warden Galpo like unequivocally said that camcorder did not have sound. So when I sat in that courtroom, I was stunned to hear that it had both sound and video. And so she initially entered it into evidence. And then she's like, wait a second, it has sound. She's like, nope, I'm not going to allow the sound to be heard. So then they had to kind of roll it back. They said, all right, well, we can't put it on right now, because obviously we put together has the sound on it. So will the appellate court be able to see the video with the sound? Because that's the same camcorder that they were taking the videos of Richard Allen trying to prep for his trial with his attorneys that they were recording him with, where I was like, I've never heard of a camcorder that doesn't have sound. Like early on, I was furious about the fact that they were sitting outside the room, turning his chair to face the window and recording all of that while he's sitting there trying to have his meetings with his counsel.
Well, I look at it like this. If trial counsel made some sort of an objection and wanted the sound in and they lost that objection, then if the audio videos aren't in, you can recreate the record. You can go back and require the trial court to get the copy that should have been admitted. What should have happened, and I don't know if it did in this case, what should have happened is you put in the recorded one and the muted one. You put them both in. Same exhibit, you make 1A, 1B, whatever, however you want to do it. And that way the appellate court, if they want to see what the audio was, they can. If that was done, great, you've got the record. If it wasn't, you can go back and recreate it and add that to the record. But here again, if trial counsel didn't object to that, appellate counsel's not going to worry about going and recreating that because they're not going to have an issue to raise on it. Yeah, there may have been a strategic reason or otherwise why they didn't want the audio to be played.
Okay. All right. That's a good answer. So this is an interesting question in terms of, and I don't know if it has anything to do with Andrea's petition that she filed or not. I think that there's a law pretty in stone in Indiana with respect to access to public records. Give us an idea. Is there a time in which these exhibits that were used at trial will ever be made public? Or
I think so. If they're not confidential, if they weren't sealed, yeah. And here's a perfect example of that. When we filed the original action, either one or two or both, people were able to get those. We shared them because they were public documents. People were able to go on and get copies of them. That's the Court of Appeals. That's the Supreme Court. They use the same system. That's how it's going to be. Unless it was sealed, confidential, they will be available to the public. Yeah.
And so would that include the video of Richard Allen in cell?
I was just going to tell you, I don't know if that was sealed or if it was merely turned away from the audience. I don't know.
I don't think it was sealed. I didn't hear anything about them saying it was sealed. It was like, because originally the first time when they were going to play it, which was the day prior. Okay. So they were like, Brad had the screen set up. He was getting ready to play it. And then there was an issue with the way that kind of their sheets that they had prepared for the jury in order to kind of follow along with the different clips. Cause it was a cumulative video, meaning that they had put a bunch of clips together of different days, different times. So like they wanted the jury to have an understanding, okay, this was April 7th, this was April 10th, this is April, whatever. So by the next day, when they actually showed the videos, that's when Brad asked if he could turn, and Gull said it on the record. She said, for the dignity of the defendant and other people's in the court, obviously Kathy, who was never going to sit in there for those anyway, not because she didn't necessarily want to see them, because I think that she probably did want to see what they were doing to her husband, but for Rick's dignity,
right.
She didn't want him to be like him at his absolute lowest point of his entire life, having his wife, who he adores and loves, sitting there watching it, so like, I don't think that it was sealed. I really don't. I didn't hear any language like that. So, all right, that's good to know. I think that those making it out to the public is so important. So important. It's the entire purpose of the transparency that we're always talking about with the courts. Like
right.
Those videos are going to be exactly why we have why we demand the constitutional right to transparency in these cases. We have to know what our government is doing to us. Yeah, yeah. Exactly. So, all right. Hey, Michael, welcome to the party, my friend.
Hey there.
What's going on? So I saw you immediately. You were on fire after post verdict, almost immediately. You're like, I'm starting the post conviction stuff immediately. I'm boots on the ground. I'm out the door. You're already cracking the case. And so I had the conversation yesterday with Cara. She's like, Michael and I are butting heads on this concept a little bit. So why don't you tell the folks what you're thinking, which approach you think that this should take initially right out of the box?
It's not what I think should be done right out of the box, but I think it's an important look. In the end, Rick Allen and probably the defense lawyers now are going to decide what to do. But there is a rarely used and procedure in Indiana. I actually made big hay out of it in the Seventh Circuit once upon a time. Where you can suspend the appeal. Sometimes they dismiss it, sometimes they suspend it, the language changes, but in any way, the basic idea is the direct appeal is set aside so you can immediately proceed with the post-conviction claim. In other words, the stuff that is not in the record now. And there are certainly people who think that, and there are all kinds of reasons that this procedure is called the Davis-Haton procedure. These days, I'm old enough to just call it a Davis petition. It's a little bit like in federal court. I still, the state cases, the state claims that went along with federal claims used to be called pendant claims. Now they're called supplemental claims. So, you can tell the age of somebody by the terminology they use. But there are advantages and disadvantages to both things. I have been saying, I think, since we first made contact with one another, Bob, I think you will recall I've been saying that basically the defense is going to have to solve this case.
Yes, I think we were both saying that, and we were both extremely concerned with the fact that we knew that the way that this thing was running down the tracks, that they weren't going to have time to do that. I think we were both pretty concerned about that fact as this thing was just, cruising towards trial. And you and I were both pretty adamant, like, wow, we're nervous about whether or not they should be rushing it to trial, because it seems like there's a lot of work to be done. And I think to go to that point, when you have this issue of these confessions, which again, I'm extending an invite to any juror that may happen to watch this. We would love to talk to you. It's a completely safe space. I just want to know what your decision rested on, or if it's multiple things. Like I'm dying to know. Like, and that's the same in any of my cases. I always want to know what turned it for the jury. Did you hate me? Was it the evidence? Did you hate my client? And he shouldn't have testified, even though I told him not to. And he said, yeah, I'm going to testify. It could be a million things, right? It could be a combination of things. It could be one thing. It could be like, well, I'll tell you what, if they didn't have the confessions and they just put that other evidence on, we wouldn't have convicted them, which tells you it was the confessions. So, as far as that goes, it's like, you have to kind of, like when you have confessions, I feel like you have to solve the case. If you're the defense, it's not the way it's supposed to be, but reality is very different than the way that it's supposed to be, than the way it's written on paper. Like, and anybody who's tried cases in this country knows that. Every defense attorney that you talk to will tell you, yeah, if I feel like I have to prove my client innocent, which isn't the standard. We don't have that burden, but it's just the way the reality works.
Well, and so when you get the post-conviction case started, you've got subpoena and deposition power again. and the investigation can continue. And it's not just, and there is evidence. I mean, look, none of us here knows what Brad and Andy and Jennifer have, what the investigators have. We don't know what the discovery is. We don't know what their own investigation has turned up or not turned up. But my eye, there is a bunch of stuff that needs to be investigated as soon as possible. And it's not just crime-related stuff. I think there is provable misconduct by law enforcement. But that's going to require subpoena and deposition power.
And so let me ask you that when that becomes kind of a focal point in terms of subpoena power and the investigation into that, how does that work in the PCA or the PCR world? Like how does that turn into, what does that turn into? So say for instance, you're able to prove that there was in fact this corruption that you were thinking, and the misconduct that was happening. Like, what is the end result of that if you're able to prove it to, the courts?
Well, you may, depending on what you come up with, it may be so conclusive that the state folds. You may not have to prove it to the courts, and if some of the things I'm thinking about, and you talk about corruption, I hesitate to go the corruption route, but misconduct doesn't have to be corruption. It's just misconduct, but you could call it, it's a kind of corruption, I guess.
I think they're in the team photo of one another.
Yeah. I'm going to use that line sometime. That's good.
Right.
But some of the things I'm thinking about, I'm not going to go into them. After Brad and Andy and Jennifer have had a chance to lick their wounds a bit, I'll front my ideas, and I'm sure Cara will be in touch with them too, and maybe we'll all be in touch with them together, and who knows? But in the end, it's going to be, there are certainly downsides to this. I mean, I think one downside, you want to start playing chess. One downside to this is that, as great as some of Rick's claims are, and you all are going to a lot of people are going to the third party stuff. I'm going even. I mean, there are claims here where you don't have to show prejudice. And I say claims, multiple claims.
And I mean, and kind of one of the two differences, at least in terms of the direct appeal, or if it were to go the post-conviction route. I mean, in the post-conviction route, I mean, aren't you almost having to bring up ineffective assistance of counsel? I mean, isn't that going to be something that's going to have to be raised?
Yeah, for sure. But I got to tell you that I'm not optimistic that, given what the mistake they made would have to be so shocking.
Right.
I mean, given the job they did, I don't give much hope to any idea that Brad and Andy were ineffective. I have a lot more hope that there's a state interference with counsel claim here.
Yeah, and like I sat in for every day of the trial, and obviously there were, and this is just from me sitting in there as a defense attorney, trial lawyers, strategically there's obviously things, and it's easy to sit there as an armchair quarterback saying, oh, I would have done this, I would have done that, but in terms of what she left them in terms of providing a defense for Rick Allen. I mean, I thought they did a bang up job. I thought that, you know, I mean, there's always going to be criticisms of things, and they'll be the first ones to say it. You know, should we have put Kathy on? You know, I mean, like that will probably haunt them. If that turns out to be something where, you know, jurors start talking a little bit about, you know, things that they needed to see, and that turns out to be a thing, you know, I mean, that's, you know, they're feeling that. Like anytime you lose a case like this, you're sitting there as the trial attorney thinking like, oh my God, what didn't I do? Or what should I have done that we made the decision not to do? You know, so like in that sense, like I've honestly, Michael, in cases that I've handled, I was actually very envious of what Brad was able to get on with respect to the conditions of Allen's confinement in order to be able to try to you know, mitigate those confessions. I mean, he got in a huge amount of evidence as to what was going on in that prison where, you know, I had a similar circumstance in that Garcia case that Allison and I tried, and you know, I didn't get anywhere near as much evidence in as to what was going on with my client in there. And our guy was mute by the time we got to trial. He hadn't spoken to us in 6 months. They said that he was malingering, you know, that he was choosing not to speak to us. I'm like, if he's malingering, it's the greatest show of willpower that I've ever seen in my life, because I've never had a client that can't keep their mouth shut at that table when I'm trying their cases. They're always in my ear. I'm sliding the pad towards them like, I have to listen to this examination. Please write your questions down. I promise I'll read it. You know, it's like for a defendant in what that was a 5.5 week trial, for him to sit there silent the entire time was incredible. You know, like it was legitimate in terms of him being, because we kept saying he's incompetent to stand trial at the time of trial, you know, and the judge was like, well, we think he's malingering. So, you know, it's one of those things where Brad really, he's going to give, like from the direct appeal perspective, he's going to give the appellate court a lot to think about in terms of the voluntariness of those confessions. And Sleuthy had a really good question that I wanted to ask both of you. If he's been involuntarily medicated with Halidol, can you make the argument that therefore the confessions are involuntary? Is that an argument that has any kind of weight?
Look, confessions are now on the prosecution side. There is nothing to be done with these confessions in an appeal, I don't think. Cara may well disagree.
Yeah, I disagree, but
all right, good. Let's hear it. Disagree.
Well, because I think that they filed pre-trial some. Didn't they file a motion to suppress? And I don't. Yeah.
They filed a motion to suppress. I don't know what the objections were once the stuff came in. And frankly, the motion to suppress, you know, Brad made arguments with respect to various buckets, but he wasn't very specific about the buckets. The motion to, I mean, I just didn't think that motion to suppress was going anywhere. And the two that they played, everybody's going to be, I mean, there was certainly testimony that he could have had moments of lucidity, right? I mean, yes, there were they could be false confessions in moments of lucidity, or they could be, he'll say anything to get out of there. But the law in Indiana used to be that the state had to prove to a jury beyond a reasonable doubt that a confession was voluntary, but that changed. I haven't pinned down exactly where it is, but now the Indiana Supreme Court saying the question of voluntariness is for the judge, and then there's this pattern instruction, which I don't think was given, on the jury basically figuring out what weight to give a statement made by a defendant from all the circumstances. I just don't think there's nothing. So you have these two confessions have these two confessions with Rick seeming pretty lucid. Gull said voluntary. Now, she may have said voluntary with respect to all of them, also without specifying which bucket. But I just I don't see a court reversing based on the apparent. I wasn't in the courtroom, Bob. You were.
Yeah, and
But
frankly, Sleuthy saying that she remembers the objection, and maybe she does in terms of one of us saying it, because I don't have my notes with me, in terms of renewing the objection, despite the fact that the motion to suppress had been denied. Like any of us that do this for a living know that you have to renew those objections at trial. You can't just hang your hat on the fact that you filed a motion to suppress pretrial. I don't remember that happening. I know where it did come up was during the instruction, if you want to call it the jury instruction conference. Brad had wanted an instruction, and I forget what the case is. You guys might know what it was, relating to the jury was allowed to reach the conclusion that the confessions were not trustworthy, and it was language that he wanted to pull directly from this case, which I have in my notes, the case name. But McClelland's response was that exactly what you just said, Michael, which was, well, it's two pronged. That the judge, in order for the judge to read that particular language that you want read, the judge must also say that I have gone through these all of these confessions and I found them to be voluntary. So at that point, Brad withdrew the request to put that instruction in. That was the most detailed kind of argument about that issue that came up that I heard. So I don't know.
Do we
well,
know?
Go ahead, Karen.
I say, do we know when they got the actual videos of his confinement? That's where I was kind of leaving it open. I got the feeling they did not have them for half of 2023 at least, because I don't think they had them. Obviously, they were still videotaping them. What, April? And then June, I think there was a hearing. It's been a while, but I would be looking at whether they had them even at the point that they filed the motion and made those arguments. If they didn't have them, they may not have known the extent of the conditions. That's why I leave the idea open of something maybe being there to be able to raise, because we got to look at the timeline of the discovery, because the state was, hell, they were still given discovery at trial, it looked like, or at least, that's what the impression I got. They were given discovery right up to the end. So that could be, that to me, that might be one of the themes is, constant complaining about you're not giving me everything. Yeah, we are. Oh, here you go. And so if that happened during trial and there's a record of it, you could maybe weave that in. Sometimes you don't raise issues you think will win. You raise issues that you think will move the needle, a little bit further on an issue you do think. Like, judges are people, and so they do act sometimes on emotion as well. If they don't think somebody's been treated unfairly, they're not going to give your claims as good a look as if they feel like something feels wrong here, something went wrong. So sometimes you raise issues for that reason too.
Well, I'm not saying that you don't talk extensively about the conditions under which Rick was kept. I'm just saying that there's no issue there that's gonna win. I don't. For a civil case, that is not, and that's the other thing. On the other end, I hope we're close on to the 2-year statute of limitations on the civil case against the Indiana Department of Correction and all those fine people. And frankly, a lot of people have, I don't know,
Well,
surmised. A lot of people have surmised that the fix was in. In fact, there was stuff going on between the prosecution. I mean, this was intentional. The place that would come out would be in that civil lawsuit in discovery, and that's why that should be pursued immediately.
That I agree with.
Yeah, I think there's a plan for that. As far as the safekeeping hearing in June, I think it was June 15th of 2023, they definitely did not have the video from the prison. That's where Gull famously basically called Rosie a liar, saying that he was exaggerating the conditions of his confinement. Obviously, if you would have been able to play that video, I think that would have shut her down right then and there, and really kind of changed the game early on. But the fact of the matter is that we learned from the last witness that the state put on in rebuttal, this Dr. Martin, like from what I hear, the last, if you want to term it a confession, where he claims that Rick Allen told him, I want to apologize to the families on June 20th. And at that point, he had opined that he didn't see any kind of symptoms of any kind of psychosis going on with Rick Allen on that day. That's when, during the cross, Brad played the video from that very day of June 20th and shows Allen catatonic. So, and that's when he changed his course and said, yeah, no, I don't feel the same way now that I've seen that video. I think that he was exhibiting symptoms of being in psychosis at that point. So, like, you're right. And those are the things that I want to know. Like I want to know, when was the first time that Kathy actually got to physically see her husband? Because I know that it wasn't during the period of time when Rick was making the confessions. I think what it's going to end up showing is that she sees him shortly after June 20th, that after all the confessions are in, at that point, they finally say, all right, we're going to let Kathy come see him. And I mean, to me, if you're using your common sense and it's like I was telling Cara yesterday, but I don't know how this argument works with the appellate court. I don't know if you're even allowed to make this argument because it wasn't really brought up at trial. And I didn't know how they would get it in, short of putting Richard Allen on the stand, that yes, they were promising me that I would get to see Kathy if I told them what they needed to hear, or that I would get transferred out of this facility if I told them what they needed to hear, so, I mean, maybe that argument's completely waived, but isn't that in conflict with his Fifth Amendment right? I don't know. I don't know.
Well, they could have presented Kathy, and it may have gotten in. I know that somehow somebody said she visited twice. So I don't know if they had dates attached to that testimony or not. I mean, or
that's
again,
wrong, Kate.
What's that?
I was Kate is in here just saying wrong things. That's incorrect.
So they had, they also, the Court of Appeals will see everything that was put in the court file. So it's possible it came in somewhere else, maybe attached as an exhibit or something, because, nothing was public in this case. We really have no idea what was attached to all of these different motions, because I think almost none of them included the exhibits as public records. So, or I should say they were public, but they weren't allowed to be given to the public or shown. So we have no idea what they've attached and what they haven't. So maybe somewhere else.
And with respect to objections, it's altogether possible that, in chambers or during white noise, Gull said, Brad or Andy said, we want to object to this stuff now. And Gull said, okay, you don't have to object at trial. And it's a little dangerous. There are a few cases going both ways, but, we don't want to interrupt the jury stuff with just objections that you're going to deny. I just don't know. But yeah, I'm, to me, looking at this, I think Cara's a lot more careful than I am, but,
yeah, Cara,
and therefore better. But to me, the theme of this was kind of spoken by Andrea the other night, that when she said, to me, this is just not a crime of opportunity. And so it's not a crime of opportunity. And if we had been able to put on the evidence that we wanted to put in, both about the third party guilt and the arrangement of the crime scene, and the obvious deception on the record by law enforcement, then I'm not talking about anything else you can prove. I'm talking about what's on the record now, right? I think I'm not saying there aren't other issues. In fact, I think the first issues are the things I'm thinking about where you don't actually have to show prejudice. I think there is, on the record of this case, there is a practically overwhelming case of judicial bias, which would be an automatic reversal, going all the way back to Gull saying to Libredo and Scremin, if you adopt the Franks memo, I'll give you a hearing. And then when Brad and Andy show up again, denied without hearing. And that's just the beginning. The whole contempt thing.
How does that interplay with the fact that that was one of the 3 points that Cara raised in her original action, was obviously that, Gull was biased, and we felt that there was strong evidence of that. And, the one thing, and it wasn't really argued by either side, not to anybody's fault, it just never came up. It seemed to me, and you guys both know how this thing works with, when you're in front of a panel of Supreme Court justices, if they're going to talk about the things that they want to talk about, that's what they're going to grill you on. And, if you don't bring it up in your little brief opening, so you have a very limited amount of time. And if you guys don't understand how fast 15 or 20 minutes goes when you're trying to make a legal argument of this magnitude, it's like blinking your eyes and it's over. So you have to be extremely careful and extremely thoughtful with the things that you feel are most important to you in those arguments. And obviously in that situation, getting Brad and Andy put back on the case was of ultimate concern. But because that issue was addressed at the Supreme Court level, how does that vibe with the concept of trying to argue it down the road? If in fact the thought is that it's ultimately going to make its way back up there, you know what I mean? Is that going to be something where they're going to be like, well, you argued this prior, or is it, Michael, where you feel that yeah, because I know you've always been in the mindset that there was a lot more bias out there that wasn't properly put out, in whatever fashion, not necessarily by Cara and the OA, but when the defense tried to get her booted themselves, that you felt that their particular motion was lacking, in that there were so many other instances that you thought showed bias that they just failed to bring up. How do those things interplay with that at the appellate court level, and most importantly at the Supreme Court level, if it's denied by the appellate court?
Well, the business about the Franks hearing is just the beginning.
Yeah.
And it's not even the beginning. That back in June, I guess it was, of 23, calling Brad a liar over the, and from which there was, given the rules of professional conduct, without evidence that he's lying, and there was none. Normally you can't allege judicial bias based on orders. I get that, but we've got everything from a completely illegal, Brad's a liar, pulling him off the case, not just pulling him off the case, telling him not to work on the case while I'm teeing you up to get rid of you, to a completely lawless, illegal contempt hearing, which she knew was illegal, to at the contempt hearing creating hearsay exceptions for the state's evidence and then denying the defense evidence. I can just go on and on about this stuff. And at a certain point, you can't have a fair trial. And by the way, that plays into, the theme of we didn't get to put on our case, which would have proved this was not a crime of opportunity, which was the state theory that Rick Allen, this was just purely a crime of opportunity. And, but this goes into, Gull was selected by the Indiana Supreme Court. Not only was she selected, but she was put back by them. I mean, even the murder sheet. I mean, when I was on the murder sheet and going through how this, the various ways the original action could come out, even they were laughing at the idea that the lawyers would go back, but Gull would stay. I mean, to me, it was sort of inconceivable, but that's what they did. So getting into the appellate process now, as Cara said, it's going to take a year. I would say it's going to take probably closer to 2. And I think the Court of Appeals is going to be a lot more generous with time in this for both the I understand they pride themselves on being the rocket docket, but this is a little different. But this is going to be up on appeal in the Indiana Court of Appeals and on transfer in the Indiana Supreme Court if necessary. Well, no, it'll be on transfer because the state will ask for transfer. In 26, when Gull's up for re-election.
Yeah, kind of that concept of this not being a crime of opportunity, it's like, how does that get argued at an appellate court level? I mean, because there's a lot of things you could say about that. Like how is it that Rick Allen admits to seeing 3 girls, which was actually 4, if it's as the state says, that it's the same group of girls, if it's Voorhees and Wilburn and then the 2 sisters, the 2 younger sisters. So he's got that wrong. But at what point, how is everybody else that sees Rick Allen, how isn't Rick Allen seeing them? Meaning, why would he say that he saw anybody if his mindset was going to be, well, I saw them, but why doesn't he say that he sees Betsy Blair if that's him out on the platform? Because he's already said he's seen 3 people.
And the answer, I mean, the answer is he didn't see him because he wasn't there. I mean, and nobody said that they saw Rick Allen.
Right.
And I think it's only Carbaugh who said, yeah, he's bridge guy in the photo. And some of the evidence that Court of Appeals is going to see the evidence of the sketches that didn't come in, and the Court of Appeals is going to see the descriptions. 5'10", 5'11", taller than me. Rick Allen's a little guy. I mean, you get that in. I mean, look, not being this evidence not coming in is actually a constitutional violation. I think it's a state evidentiary violation too, but it is a constitutional violation not being able to present a complete defense. The standard for that is if they find the error, the state has to show that error was harmless beyond a reasonable doubt. I don't think anybody, I don't think that succeeds. And the only way that succeeds is if the Indiana Court of Appeals, or eventually the Supreme Court, says, yeah, there were these confessions.
I mean, but that's the concern.
Yep.
Well, that's one of the reasons. That's one of the reasons I think that my tendency, and again, it's not up to me. I certainly see downsides, but going ahead with the post-conviction case ASAP, me makes a lot of sense. And this is a procedure, by the way, I have said for forever is just terrible. One of the reasons it's just terrible in most cases is that you essentially give up later any claim of ineffective assistance of the appellate lawyers. Because what happens is the post-conviction lawyers and the appellate lawyers are the same. But I also
Right.
have to say, but I also have to say, the issues in this case are so obvious and so huge. Giving up an appellate ineffective assistance claim in this case is silly because the standard is a silly problem to think about, because the standard is, was the issue that you left out clearly stronger than the stuff you included? There's just not going to be any issue like that.
Yeah, see, like the hardest thing for me to kind of grasp is like during this 2 years and 2 years plus at this point of this process. I mean, you guys know how it is with judges on the bench. Like it was nobody in her ear talking about these decisions that she's making, these rulings that she was coming down with, and the fact that that she was doing them without hearing, that she was not citing any law or giving any rationale as to why she was making the decision. Like, were none of her colleagues saying, "Hey, like, you may want to," like, I mean, does Gull just not care if this thing were to get overturned on an appeal, or is she so confident for some reasons unknown, that it's not, that she just felt that she had free reign to do whatever she wanted? I mean, like, to me, it would just seem to be common sense that her colleagues would have been saying, "Hey, like, take it or leave it, but this is my opinion on this, and maybe you may want to change your approach a little bit," because it seems to me that if every other lawyer in the state is sitting here saying, "Look, this is reversible error," you know, all the lawyers in the state can't be wrong. You know what I mean? It's like she had to be hearing that chatter, yet she persisted with doing it all the way to the end. All the way to the end. It's like I've never been able to reconcile that.
I think it's a combination of the two. That she knows what the standards on appeal are on the one hand, but she also doesn't care on the other.
Yeah.
I mean, look, Nick McClelland got his victory. Everybody's hugging each other. If that crazy Court of Appeals or Indiana Supreme Court reverses this thing, not on me. Yeah, we'll do it again if we have to, a few years from now. And
honestly, that's why
yeah,
our appellate courts are set up this way. They are not disinterested, but they don't have the same pressures that the trial court has. So they are in Indianapolis. They have no connection to the people in that community. They're retained every 10 years by a voter referendum, essentially. And I like it that way because I know that they don't have the same pressures that a trial court does. So sometimes a trial court may do something, in my opinion, that I think was due to public pressure. I'm not saying here, but that's what I've seen in other cases. And the Court of Appeals, they'll punt it because they know if somebody's going to make the unpopular decision, let the Court of Appeals do it. Let the Supreme Court do it. And so that's that's a check on the system, right? I think it works when it works. So
but it doesn't work. It doesn't work often, and I will say that I have Cara's less willing to say nasty things than I, but I got a case where the Indiana Court of Appeals said, yeah, alibi witness wouldn't have mattered because there was an eyewitness to the crime. Are you kidding me? Oh, and by the way, the eyewitness was the one who was soaked in the victim's blood, and there's no forensic evidence tying my guy to the crime. But an alibi witness would not have mattered. And I mean, they just they just say stuff that it's indefensible. Some of the stuff they do. Look, I win habeas cases not because I'm any kind of genius. It's because there are state court decisions that flunk constitutional law. Period.
And I just say, yeah, there are decisions like that, but I guess that's why the system sometimes works. That's why we have a next step, and that's the thing that I'm nervous about with an idea of a Davis Haton is you're kind of you're not doing the next normal step. You're kind of skipping ahead. In some cases, it makes sense. I just think in this case, you could have the direct appeal going. But then post-conviction counsel can do what they want to do. No, they don't have subpoena power, but you can get a lot done without subpoena power. Sleuthy has proven that. She's found stuff I didn't even know you could find. So there are ways to get around where you don't need a subpoena. You don't have to take a deposition. But that's what I think is you have post-conviction doing their work while the appeal's going. And then you're kind of, what if you went on appeal? Has post-conviction counsel wasted their time? No, because guess what? They hand a beautiful present back to trial counsel and say, here, I found out a little bit more you can use, that kind of thing. So that's what I think would be the best route. But obviously it's up to Rick and trial. I'm sure he'll listen to trial counsel on what to do.
Yeah, there's certainly stuff you can do without subpoena power, but a number of the things I'm thinking about, you got to have subpoena power for, and this is evidence. This is stuff that will not be available later.
Interesting.
That's a good point.
Yeah. So as far as like the post-conviction route, I mean, one of the primary differences is that's boots on the ground investigation. Like you're literally out there having to beat the weeds to try to find newly discovered evidence, right? I mean, like can't both things happen simultaneously? So say for instance, the direct appeal gets filed, because I mean, how quickly do you think an investigation can happen on the post-conviction route? I guess is what I'm asking. Like, do you have to and maybe you just answered that question with the necessity of the subpoena power, do you have to have your post-conviction petition like somehow on the radar in order to have that subpoena power to be able to get things that you need in order to conduct that investigation? Or is that something that can happen contemporaneous with while the direct appeal is going, that investigation, because a lot of times most post-conviction stuff you see is way after the fact, right? You're trying to go way back in history and do the impossible. I mean, like from where you're coming from, Michael, I mean, in this case in particular, I completely agree. I think things are time sensitive. I think that there's going to be motive to make things disappear that they don't want seen. I think all those things are true. And I think that the longer it goes, the more likely it is that those things will disappear. So, I mean, that point's very well taken. But is there a world in which both these things can happen at the same time? So that, say, for instance, the direct appeal gets booted, it's denied, goes up to the Supreme Court, they deny it as well, and then you're ready to turn around almost immediately instead of having waited that entire period of time, whether it be a year, 2 years, and then you start your investigation, but that it's happened contemporaneous and that you're ready to file your PC like right away. I mean, can that happen?
It can, but and I don't know how the state PD's office would handle it in terms whether they'd prioritize it or not. But they've got about a year and a half backlog now, and there would be and frankly there would be no point if they're gonna. So if you did this Davis petition thing, what you do is the notice of appeal would be filed, and then whoever the lawyer is would file a request in the Court of Appeals, suspend the appeal so that they can file a post-conviction petition and pursue post-conviction relief. Rick is indigent. It would go to the state PD's office. I will absolutely agree. If they're not going to prioritize Rick's case, there is no reason to do it. None. But if they're willing to go, full bore now, and by the way, it's a perfect case for this for an additional reason, and that is that state PD's office is now hooked up with the new Indiana Innocence Project. And the way they're hooked up is two of the lawyers up there, and I mean two absolutely killer lawyers, are teaching over at the McKinney Law School the wrongful conviction clinic. And they can't do successive petitions, but they can do first post-conviction petitions. And this is a first post-conviction petition that is an actual innocence case. So those two guys with that class might be able to get onto it right away. I don't know. It's all to be discussed and worked out. And, I think Rick has great I think Rick has great arguments in the direct appeal. I just have a whole lot less confidence than Cara does in the Indiana Appellate courts. Of course, what I do is I go to federal court and say, by the way, folks, what the Indiana State Appellate courts did, no fair-minded jurist would do. That's the standard to win in federal court. And so I have a definite different perspective on the Indiana Appellate Court.
All right. Well, I mean, I think where we're at right now is that there's a lot of discussions that need to be had by a lot of different people, all of which are of the same mindset that we want to try to help Rick Allen. And I think that I agree. I mean, time is of the essence. I am, and I said it at the opening, and I'm going to say it again. I am extremely worried about him staying alive in prison. I think that Kathy feels the exact same way. I think that anybody that understands what's been going on with this case, because there is zero incentive by anybody from the government side of this to keep Rick Allen alive. I think that the last thing that anybody from the state side of this wants to do is have this thing litigated in the appellate courts and or the federal courts eventually down the road, or God forbid, a post-conviction relief act type thing where, there's a lot of digging in going on and, secrets are trying to be exposed and things like that. It's there's a lot of downside for them, and there's little to no incentive to ensure that he stays safe throughout the process. So to me, that's the most pressing issue. There's I don't think Rick Allen survives 5 years in the DOC. I just don't. Whether it's by his own hand or whether it's by somebody else doing it, everybody who is in this profession and people that are acutely aware of what goes on in prisons around this country with respect to convicted child killers and, sex offenders that have committed heinous acts against kids, they don't fare well. That's facts. And Dick and Rick is a fragile egg. I mean, there's no question about that. He goes in as a fragile egg. He came into the system as a fragile egg. If you're to believe what Westcott says, and I have no reason to doubt her, I found her to be highly credible. So I'm concerned from that side of it for certain. The one thing I'm not worried about is that there's a bunch of big brains out there that are willing to put up the fight. It's going to become an issue of money, like it always does, unfortunately. Because it's one of those things that the way our system works is the people with the most money typically get the best representation down the line. So and I hope that is not the case here, because I think there's going to be, I think funds can be raised but it's certainly not going to be an endless well. And, there's going to have to be some folks out there that are willing to, take less money than they would typically take in order to fight this fight because they think it's that important. So, that's what my hope is for certain.
I mean, I mean, in terms of time, I mean, I could easily see this appeal taking 800 hours. At $100 an hour, that's $80,000.
Yep. And that's bargain basement prices for an appellate.
And by the way, 800 hours, I mean, law firms, big law firms want people to bill 2,000, but 800 hours is like half a year of a lot of lawyers' work.
Yeah, it is. So, all right. You guys have any closing remarks? Anything, either of you?
Just hoping for, justice for Rick. And I think it's okay to say that. And it doesn't say anything about Abby and Libby and their families. You can be upset about what happened and upset that it doesn't feel like they got justice because they've got the wrong person. I think you can hold those two positions and they aren't contrary. So I am hopeful that we do see justice in this case. I don't think it's been had, and I hope we get it.
Michael?
Yeah, as always, I'll just go along with Cara because, yeah, I have said from the beginning, I truly think that what happened to these girls is much more horrible than anything this tape proved, and that this was not justice for them, and that the real people who did this need to be exposed. And I have little hope that they can be prosecuted anymore, but they need to be exposed.
Yeah, and that is that's a thing. That concept of those two concepts of thinking that they have the wrong guy and still wanting justice for Abby and Libby are not mutually exclusive things. I say it all the time. It's the families don't get true justice and unless they get the actual perpetrators. And where they're at probably mentally right now is feeling relieved. They've been told by the state of Indiana and Nick McClelland and law enforcement, this is the guy and we got him. So like they're sitting there right now, probably not understanding, the appellate process and what's coming down the pike. And one thing that I talk about quite a bit on my lives is that, prosecutor offices are notoriously bad on keeping family members apprised of exactly what's going on. So when they see appeals being filed, they don't know what it means. They don't understand what it means. They like, is he getting a new trial? Like they just don't have that basis in the law. They don't have the understanding of what this process is. So, it's this thing is just getting started from the post-conviction stage. I mean, like this is going to be a long and scary road for them if they're of the firm mindset that they got the right guy. And they sat in there, they sat in there for every day of the trial. They heard the evidence, and and if they feel in their hearts that justice has been served, then like I'm no one to say that they shouldn't feel that way. I mean, like we're all allowed our own opinions on the case, and I realize I'm a criminal defense attorney, and I realize that I'm talking with two people on the criminal defense side of the bar, so we look at things probably a little bit differently. And I think that we all recognize that, but like just looking at it from an intellectually honest perspective, again, I'm going to state it. If you pull those confessions out of this thing and that thing would have been brought to trial with that evidence, I don't think there's any way in hell that Richard Allen's going to prison. That's my opinion on it.
Well, let me push push back a little bit on yeah, maybe I have a criminal defense attorney perspective. On the other hand, I was 86-0 at the Attorney General's office some time ago. And the other thing is that to do the kind of cases I do, and I think I said this maybe on an earlier live with you, Bob, and that is, before I can even think about winning in the kind of cases I do, I got to think about all the ways I can lose. And I don't think I'm kind of looking at the facts here and the claims, and then there's my knowledge of the courts. But I mean, on the facts and the claims alone, in an appeal, this should be a lay down winner.
Yeah.
But then you got the court.
Right. Yeah. And then there's reality, so yeah, I appreciate you both. I respect the hell out of both of you. I think you're both brilliant attorneys in your own rights. And, I look forward to having you guys on as this process goes through. Obviously, I'm hoping that both of you are going to be intimately involved with this process moving forward, as I've been, become friends with both of you, and I respect both of you and what you do and what you've accomplished in your careers. And I would feel very comfortable knowing that, Rick's fate would be in your hands, because there's one thing I know about both of you is that you care. And as I told Cara yesterday, I'm like, knowledge of the law is one thing, but if you get that just incredible combination of a lawyer that has knowledge of the law and actually cares, it's a powerful thing. So, that's where I stand on it. And, I appreciate both of you coming on today, and, it will certainly not be the last time, cause we're not going anywhere. Any of those out there that are worried, none of us that have been involved
Right.
In the background of this case, we're not going anywhere on this thing. So, all right, you guys, I adore both of you. I'm going to cut you both. I'm going to say goodbye to everybody. I'm not going to torture you, keeping you on with, with me thanking people, but
thanks for the opportunity.
Yeah.
Always, Michael, always. All right, you guys, thank you very much.
Thanks, everyone.
All right, take care. All right, you guys. So hopefully that gave you guys some insight on kind of what this process is going to be like, what you can expect, kind of timing of things. As you can see, there's some questions and some debate on how it should be handled that are both legitimate and both very interesting. And I think that, there's enough people out there that care about what's going on overall, not just on Rick Allen's case, but for, the entire process, that are going to be getting involved with this thing. And, and it's going to be long fought. Like, I just want everybody to know that, it's like, I tend to agree with Michael that probably the more closer to the 2-year mark, but I don't practice appellate law in Indiana. So you can't discount what Cara's saying, because she does. And she does it all the time, and she does it very well. So I hope I got most of the questions answered in there. And then, cool lady, I just wanted to give my thanks real quick. Thank you for the DD podcast memberships going out, and I'm sure the folks that received those, we're thankful for those. Wasn't the jury able to see through the torture? Apparently not. And thank you for that $2 holla. They came with their verdict, and they saw it. They saw it firsthand. They saw more than we did as a gallery. Shabugi's, I think his voice did it. Does he sound like Bridge Guy? I couldn't even tell you. It's like the limited part of that case was how few times we were shown any of the videos. It's like, I think we saw the enhanced twice total. And the only other time we heard Rick Allen's voice was during the 2 interrogation videos, and then on the phone call confessions. So, he had no effect on the confessions. Like, so you can't really get a judge of what he sounds like normally So, you have to kind of use the two interrogation videos as what he would sound like in a, I wouldn't call that a normal circumstance, because when you're being interrogated by law enforcement, that's not a normal circumstance. So I couldn't tell you. And beyond that, I'm not a voice analyst. So I don't know. I don't know. Um, she could be, if it got kicked back on appeal. I think that certainly she could be, unless one of the grounds of the appeal is bias, in which case the part of the remand could be that she's not going to sit on it. I mean, if they don't bite on that part of the apple and she's still active and on the bench, I mean, she certainly could be the trial judge again. Um, does he have to go with the attorney Gull appoints? If he goes the indigent route, Gull is going to, and Gull's going to have a say so on who's appointed in terms of the appellate defender, and they'll probably go from like her county. So, I mean, in a kind of collateral way, yes, she wouldn't be able to handpick anybody, at least on its face. But yeah, I think that if they end up using Allen County because that's where she sits, and they use an Allen County Defender's office, I mean, you take what you will from that. Crypto, be money, Cara, that is all. Appreciate you. Appreciate your generosity always. Crypto, going to trial, throwing 3-sided dice, NG hung. That's what it is. I mean, a lot of times, and most of the time it comes up with that G. That's the facts. I think I put that up, Allie. Yeah, I mean, that's going to be something that's going to happen. That's for certain. There's going to have to be a fundraiser because the Allens certainly don't have the money for it. And I saw this. We appreciate that. I know there's a lot of people out there that want to be able to help in whatever way they can. And I have to say that I'm just so appreciative of the people out in this community and other communities, and just that I see on socials that are willing to give critical looks at our justice system. And and in this case in particular, I've never seen a case where there's so many people that don't trust this verdict. Like, I think a bulk of the people, and I think it's the fairest thing to say, is that, like, you don't, like, none of us can know whether Rick Allen did this or not. But what we know is that the process was wrong, that there was something wrong with it. It was not the way it's supposed to be from beginning until the end. It's not how our justice system is supposed to operate. And I think most people kind of fall in that area where people will say, I don't know 100% if he's guilty, because none of us can know 100% whether he's innocent or guilty, whether he did or he didn't. So we weren't there. Like, it's the simplest way to put that. Like, people that are adamant about his guilt, they weren't there. They don't know. Just like anybody who's saying he's innocent, they weren't there. They don't know. But what you do know is that you have eyes, you have ears, you have brains, and you can see the process that took place in this case. And it doesn't feel right. It doesn't feel right in your gut. And that's what I'm appreciative of. I'm appreciative of people out there that are willing to kind of put their necks out and say that, and and join me in questioning. And we are the watchdogs. That's why we demand transparency. We need to know what the government's doing, and this is the government. So just know that I feel deep gratitude to all y'all out there that are along with us on this fight. Couldn't Richard Allen have testified at a motion to suppress confession without opening up the door to testimony about yeah, I mean, they could have put him on. I mean, I, like, many times, Allison and I have thought about putting our defendants on in a pretrial hearing for a very limited purpose, but it's always a crapshoot. I mean, I'm certainly, it was discussed by the attorneys because of things that may come from that testimony in terms of things that could be used, because if you get like, kind of the concept is, it's scary to put a defendant on because of the way that people perceive things, and you never know that one word can be misperceived, and you have that turn into something that it's not, and like you saw it in this trial. Like you had two very differing opinions on this thing where Rick Allen says, well, if that picture was taken on the girl's photo or on the girl's camera, it wasn't me, and you have the state using that as evidence of guilt. And I'm sitting here thinking, I'm like, what are you talking about? I mean, he's saying that it's impossible that if that picture came from Libby's phone, it can't be me because I wasn't there, but so that's what I'm talking about. Perception, words matter, and words are perceived differently by different people. So it's always a scary proposition to put your client on the stand if you're a defense attorney. I saw this, and actually, I did watch that, Miss Osland, and appreciate your generosity. I did watch it, and it is very interesting, that Michelle After Dark video. It is. She always digs in hard. Chris, I'm glad that you found me from Peter. Appreciate that. And yeah, I'm pretty proud of my dad. He was a damn good lawyer back when he was practicing. So thank you for your generosity as well. Cara is right with Jane Doe. Thank you for your generosity. Use of misconduct as the backbone to connect all the loose facts into a concise point that shows Mr. Allen has been made into a scapegoat. Yeah, I mean that's going to be the battle in the brief, and it's tough. It's tough to do. It's tough to convince appellate courts. Just as it's a real uphill battle. Jamie, appreciate you. Thank you so much. Biased juror, thank you so much for your generosity. Maced, will he get a reward since it was his tip that led to the arrest? Somebody said he would. I don't think so. Like in this world, you can't gain from there's no such thing as ill-gotten gains. So, and considering he's now convicted, that would not happen. Donna, thank you so much for your generosity. And then Jessica, thank you so much as well. Why wasn't he required to testify based on the videos and calls of him? Was there a clause? No, I mean, those are certainly like overall would be considered hearsay as they're out of court statements being offered, for the truth of the matter asserted. However, statements against interest are not hearsay. So that's how they were able to get all that stuff in. So you guys are amazing. I appreciate all of you. I will keep coming at you with Delphi coverage. I'm not going anywhere. It's my hope that I am able, once the gag is done, to get Rick's attorneys on so we can hear from them. It's my hope that I am able to get convince Kathy Allen to come on with me as well. So keep looking for Delphi content, and I'll be chugging along on other stuff. But I just want you to know, because we're covering other stuff, Rick is not forgotten. All right. Thank you guys. We love you, because without you, I'm just an old man talking about our old cases.